Lawsuits are good for America.
People without resources take on any giant corporation, any overreaching governmental agency.
Juries exist as a pure form of citizen power.
We have to use the law as a tool to end secrecy by corporations.
This is a fight worth fighting for.
Corporations have no conscience, they have no beliefs, they have no feelings, they have no thoughts, they have no desires.
Fossil fuel companies engaged in a campaign of deception and denial that resembles that of the tobacco companies.
They are not themselves members of we the people by whom and for whom the Constitution was established.
Imagine a world in which businesses redirect all consumer lawsuits into secret tribunals.
When decisions are made by some other legal power source, citizens lose.
In states with the capped recovery in medical malpractice cases, adverse incidents actually increased.
The legal system is a better arbiter of disputes than politicians are.
We're blowing up countries all over the world, spending trillions of dollars, giving hundreds of billions of dollars to corporate freeloaders and tax escapees, and we're shutting down our courts? Good morning, everybody. The theme today is an extraordinary one. It is recognizing the law of torts and the civil justice system, otherwise known as defending yourself from wrongful injuries, because you have your day in court and a trial by jury. You will see today the greatest gathering of specialists on the broadest number of subjects under tort law, the law of wrongful injury. And why is that important to say? Because the law of torts is one of the two great pillars of self-actuated freedom in our country that we inherited from medieval England. The law of torts replaces the practice of revenge. When people are wrongfully injured, unlike in medieval England, they can go to an attorney on a contingent fee, meaning the attorney is paid only if the attorney prevails, and have their day in court trial by jury of their peers. The law of wrongful injury has been under serious attack. To hold corporations responsible for wrongful injury, to expose them to depositions, to personal interrogation, upsets them greatly. Notwithstanding these rights under our Constitution and the common law of torts, utilization of tort law is minimal. It's grossly underutilized. Just to take some examples of recent casualty estimates, there are 65,000 people in this country who die every year from air pollution. Most of those are torts, toxic torts. Very few result in a legal initiative in court. 250,000 Americans die every year from mishaps in hospitals, according to Johns Hopkins School of Medicine report in March 2016. A lot of those must be viewed as torts. A tiny fraction end up in the hands of plaintiff lawyers, and even fewer end up in settlements or courts. We have many other forms of torts in this country, and tort law is not resorted to. The question is why And today there will be explanations of why. People in this country avail themselves of the Second Amendment, presumably to defend themselves, far, far more than they avail themselves of the Seventh Amendment, not only to defend themselves, but to generate disclosure of harmful activities and defective products for a wider public, and to generate deterrence against unsafe practices that harm people wrongfully. This irony reflects a lack of public education about the law of torts and the need to utilize it more, not only for justice for the wrongfully harmed plaintiff, but also for disclosure, for greater imposition of new or larger enforcement of safety standards, and deterrence radiating throughout the land against similar unsafe practices.
Tort law has three purposes. The one that people know, I got to get me a lawyer, is to get money, to be compensated for the wrongful injury. So compensation is an important part. But the other two aspects are disclosure of the wrongdoing and deterrence. A jury verdict can resonate around the country and indeed around the world to stop or halt or change unsafe practices. One of the remarkable strengths of tort law is that it is direct action. You don't need to get government approval or authority. You don't need a permit or authorization. It's directly created and started at the insistence of an injured plaintiff. It works on the basis of a contingent fee so that the plaintiff, the injured victim, doesn't pay the lawyer unless he or she receives compensation. Tort cases are done in open court. It's on the record. It's all under oath. The press can come in. The judge is there to apply the rules of evidence. All the testimony is subject to rigorous cross-examination. And if there's a mistake, it can be appealed to a higher court. Trial by jury in tort cases is as fair and safe and impartial as humankind has ever devised. So why is this important? It's important because the way tort law has evolved levels the playing field. It not only allows direct action, but it lets people without resources take on anyone in the world, any giant corporation, any overreaching governmental agency. The great historian Eric Foner, at the opening of the American Museum of Tort Law, which I encourage you all to visit, called tort law the weapon of the weak, and that is a really insightful, powerful phrase. It lets an injured victim take on anybody and hold them accountable. To quote the Wizard of Oz, it levels the playing field between the great and powerful and the small and meek.
This is not a modern system. This is an ancient system. It's about 4,000 years old, and I'll get back to that sensational temporal claim in a moment. But this is a system that needs to be celebrated because over time, it has been the force of justice. It has been the place where people who are injured and mistreated, who suffer the consequences of negligence and neglect, it has been the place where you got a fair trial, a place where there was a venue that was open to you in the states, overseen by state law judges who are part of the state, administered by a jury of your peers in that state. And it is the envy of every legal system on the planet. The history of our species is full of instances that reflect plans to deal with the probability of violent retribution and revenge when rights were violated. And the first ones that come up are from Sumeria. The right not to be beaten, the right not to be tormented, the right to keep your property, the right to keep your personal property, and the right not to be confined. And for those of you who know tort law, those are the 5 ancient trespassory torts. 4,000 years ago in Sumeria. They are also enshrined in the opening of the UN Charter. These rights, challenged in the planks of both political platforms every year since 1984, are obviously of consequence. With this backdrop, the Magna Carta kind of seems like modern history. And of course, it gives us a judiciary that's hopefully fair, a government that's limited, a jury of peers, and of course, a system of writs that becomes the backbone of tort law. And it's that tort law that we celebrate, that tort law that is the core of the civil justice system, that tort law that provides deterrence both for the products and behaviors that are the subject of the litigation and for all those looking on, for all those who understand that, gee, if that company or that individual was the subject of a sanction, then we could be too. Deterrence is the most economic, efficient modality of regulation in the history of humankind. B.F. Skinner was no fool. Punish an event and let others observe it, and that event doesn't get repeated. You don't have to punish everyone in the cage. A solid system, a common law of torts that houses literally millions of cases, that forms an almost a religious tome, a behavioral model of how we can act, full of exceptions, full of variables, full of humanity, full of impulses to do the just and best things, full of opportunities to sanction wrongdoers, full of opportunities to correct injustice, and full of opportunities to allow our legal process to be live up to its actual potential. It's tort lawyers who made it work. It's regulatory lawyers with tort sensitivities who put it into action. Everything you do at this point is a beneficiary of the tort system. Every time you get in an airplane, you're standing up on a train, you're getting in your car, you're using an appliance. It's better because of tort law.
In September of 1964, we were beginning to see signs that the law of torts might be on the verge of undergoing some very dramatic changes. Changes that would continue one way or another over a span of decades and would produce an evolution in the way our legal system adjusts the settlement of private, non-contractual disputes, which is what tort law is all about. In the 1970s, the adoption of strict tort liability for defective products would radically change an important area of tort law. Government and charitable immunities and the defense of contributory negligence would fall by the wayside as a result of judicial decisions and legislation in various states. Common law was changing. Women were allowed, for example, to recover for loss of consortium resulting from serious injury to their husbands, something that they couldn't do at one time. The liability rules for recovering damages for emotional distress were expanded. Courts did away with outmoded limitations on the duties owed by landowners to protect entrants on their land from dangerous artificial conditions, and the duties owed by landlords to protect tenants from hidden dangers on leased premises. Courts were beginning to recognize duties on the part of certain defendants to protect certain classes of plaintiffs from the criminal attacks of third parties. And a number of states began to adopt no-fault plans dealing with auto accidents. So things were percolating, things were moving. Tort law was expanding. Another way to put it, the pendulum was moving in the direction of accident victims.
It's not really commonly understood in the vast swath of America that people who were badly injured, who have a loved one badly injured or a loved one who's been killed, who come to see a lawyer, they are not just seeking fair compensation for what's happened. They are seeking reform. They don't want to see this happen again. Now, I recognize that there are some cases that are not really amenable to that kind of an argument. But so many other of the cases that come to lawyers today are cases where, if they give it some thought,
they can bring to bear their skills and their talents in such a way as to convince the defendant to change their ways. Now, of course, we have a weakness in the civil justice system in this country because we can only sue for money damages. We're not allowed to bring a claim in this country for equitable reform. It's just not part of what is permitted in the tort system or the justice system writ large. But we have leverage that is not well appreciated by trial lawyers, and that leverage is the hot breath of jury selection, jury trial, verdict, publicity, public censure, government oversight, and all that goes with that. So, in the right case, we can make a demand on a defendant that as a condition of settlement, that they have to change their practices. And I have found good success in getting that done.
So a class action enables large groups of people who've been harmed by the same misconduct a way to go to court as a group. It's often called aggregate litigation. So they go to everybody who's been harmed gets to be represented in court, and they get to sue for damages, but under the class action rules, you can actually sue for what lawyers like to call injunctive relief, but that just means you can sue to get a change in the behavior or the conduct of the corporation that engaged in the misconduct to begin with. The most famous class action I think that everybody will have heard of is Brown versus Board of Education. And that was a class action that, as we know, changed behavior and the law for the United States of America forever going forward. Class actions today, sort of modern-day class actions, are governed, I'm not going to get too much in the weeds on law, but they're governed by something called Rule 23 of the Federal Rules of Civil Procedure, and then most states also have a version of Rule 23. But what's important for our discussion today is that Rule 23 was changed in 1966. Unlike what's going on today, it was changed in 1966 to open the courthouse doors to more people. That it was recognized by the judiciary that these are very important cases to be brought when large groups of people need to redress their rights. Why do we have class actions? Why are they important? They serve to compensate victims. They serve to deter bad behavior by either corporations or governments. They're very good at discovering and then disclosing bad conduct that we wouldn't otherwise know about, and they also help to enforce the laws.
So why are lawsuits good for America? I will argue to you that while compensation is important, and I don't mean to diminish it, it's more of a important fringe benefit of the system. And the system really is about, as Ralph described it earlier, disclosure and deterrence. And that more than anything, it is disclosure that leads to deterrence. Louis Brandeis famously said, "Sunlight is the best disinfectant. The electric light is the best policeman." And what lawsuits do is they shine flashlights into dark corners with the result of making America safer, making all of our lives safer.
I'm going to talk about secrecy and the need for transparency. In 1995, a woman came to me. I had known her for years. I had represented her in general matters. She said, "My 3 children, ages 8 to 12, had changed. One was washing their hands every day till they bled. Another one was taking 2-hour showers. Another was fighting with his younger brothers, violent." And I spoke to these children, and I had known these children. They were good kids. And they told me about a priest, Father John J. Gagan, who was putting them to bed every night. As it turns out, he was sexually abusing them, and not only them, but all the other children he could find in the project who had fatherless families because the father was working 2 jobs or he was an alcoholic. It was just absentee. And I tracked him, and I worked day and night with these victims who are my heroes, these sexual abusers. And it turns out that he had abused children for over 35 years. How did he do it? How do all these priests do it? As we're speaking today, they're sexually abusing children. Just earlier this week, we outed Monsignor O'Keefe from the Archdiocese of New York, sexually abusing children. The church, the Catholic Church, private schools, Boy Scouts, Boys Club, all of these powerful entities use the law and they implement secrecy in doing so. The Catholic Church, for instance, uses the law in a canonical fashion. In their canon law, it states when sexual abuse matters are looked into, they shall be kept secret. When a pedophile priest molests a child, 99% of the time he tells the child, don't tell anyone, I represent God. If you tell anybody, you're going to burn in hell, your parents will get divorced, your brother's going to die. It is endless. The secrecy is endless. When the mother takes the child to the parish to report the abuse, the priest says to the mother, you have to protect the church. You have to keep this secret. And mother believes that. Up until the dam broke. And that dam should have broke a long time ago. A man, 89 years old, contacted me last year. He was abused in 1938 when he was 7 years old. I said, did you tell anybody back then? And he looked at me and his jaw dropped and he said, if you told anybody in 1938 you were abused by a priest, you would have been killed. You would have been murdered. Because of what has been done by earlier victims, because of the publicity, because of the law changing in victims' favors, a lot of children are now safer. I'm not going to stand here and say all of them are. That's not true. But a lot of children are now safer. Now mandated reporters, mandated under the law, do their job. At least most of the time. Whereas before, they looked the other way. Law enforcement is going after these priests tooth and nail, as far as I can tell. And they should be. And they're doing a great job. Just yesterday, the choir singer in Massachusetts was indicted and arraigned. He was arraigned yesterday.
You know, a lot of us, when we talk about environmental problems, tend to think of the government and government regulation as being the solution. And I actually happen to be someone who thinks that a lot of what the government regulators do in the environmental field is incredibly important and is just vital to America. And if a giant Cheeto or a genial pothead from Colorado were to tell you we didn't need any environmental regulations, I think they'd be totally wrong. Having said that, there's a lot that the government doesn't deal with, and there are some of these environmental issues where the only people who are actually sort of being cops on the beat who are solving these problems are private litigators.
The Tennant family in West Virginia on their farm, the cows started dying, and it was a horrible death. And they suspected that just maybe this was caused by the the dump that DuPont Corporation had upriver from them. And so they brought the lawsuit against DuPont. The poison was discovered in the community drinking water. And when it was found in the community water supplies, a class action lawsuit was filed in 2001. 4 years later, that class action settled in 2005. DuPont agreed to filter the water, to pay a sum of money to validate the settlement, and to create a science panel that would replace a jury. And if the epidemiologists found that there was a link to human disease, all of the class members would have medical monitoring to test to see if they were getting the diseases, and they would have claims that they could bring against DuPont for the various diseases. In the meantime, DuPont had to clean up, filter the water, and the filtering would continue until the science panel returned its result. We decided that what we would do, instead of just handing out the money, which would have amounted to about $625 per person, and then the lawyers get a big fee, we would take all of the money, the settlement money, we would pay each person $400, and they would provide a complete medical history. We would gather the history with the money, and they would submit to a blood draw, which would provide 4 pages of blood panels. Well, based on that, we ended up with the largest human health study in the history of the world. The epidemiologists ended up with data from almost 70,000 people. They found a connection between the chemical, which is known as C8. It's used in the Teflon manufacturing process. It makes things slippery and that sort of thing. They found a connection between the chemical and kidney cancer, testicular cancer, ulcerative colitis, pregnancy-induced hypertension, thyroid disease, and medically treated high cholesterol. Over 3,000 people now have injury claims based on it, and the entire population is being tested. We will break through the power of DuPont. C8, which is, as I said, is used by DuPont in a lot of day-to-day products. If it gets in your blood, it stays in your blood. But what should bother you the most right now is it's in your blood. The typical level for a person any place in the world is 3 parts per billion in the world. And it's not in your blood, and it's not dose dependent. Your level at 3 parts per billion is there. It's in polar bears' bloods, for goodness sakes, and they don't use Stainmaster carpet, Gore-Tex jackets, or Teflon.
So far as you know.
So far as we know. But how did it get there? DuPont put it in the river, they pumped it in the ground, and they blew it up in the air. And the reason that it's in your blood is because they blew it up in the air. It surrounded the world. The bad effects of the chemical were covered up for more than 60 years. The original DuPont criminals that put this together are no longer alive. The DuPont leaders and their lawyers intended for our lawsuit to solve their problem. We were supposed to hand out the money, get a big fee, and go away. The science panel of epidemiologists was never expected to have any data upon which they could ever find any connection between the chemical C8 and human disease. And for the rest of human history, when families of dying people pointed at DuPont, DuPont's plan was to point at this lawsuit, the science panel study, and say, C8 is harmless. This case exposed a premeditated scheme for DuPont insiders to make money while poisoning the world and to cover it up forever. Guess what, DuPont? It didn't work.
You know, with lead paint, it is extremely dangerous for children because the paint comes off in chips. Little children pick up the chips and eat them, and oh, by the way, lead tastes sweet. And they are also exposed to dust that from friction surfaces, windows opening and closing, and doors, and playing on the floor. And what's been known since antiquity, Roman times, that lead was toxic, and that lead can cause brain injury, permanent brain injury, can cause seizures and death. And yet, the lead paint companies put it into paint to be used inside and outside homes, and even promoted that it was better because some of the lead would, the paint was made to slough off, and that made it clean because the dirt of the wall would come off with the dust. So in promoting it, they contributed to the public nuisance. The result of the trial that we had in 2013 was that the judge agreed that there was a very imminent and current danger to children in California from the lead paint, and set aside monies of $1.15 billion to have the houses tested and to have the most dangerous paint removed from the friction areas, and that this would be administered by the state of California and then as needed given to the counties. So what this means is that these children can be protected, but it's up on appeal.
You get to a situation of externalization of costs. Here's some things. You have this contamination. Is it cheaper to move people out? Is it cheaper to prevent their injuries? Or is it cheaper to deal with the government and pay fines? Is it cheaper to delay? St. Joe Smelter, also Doe Run, there are two different names for it, in Missouri, were the founders of the Lead Industry Association and the ones that set up the meeting that Mary was talking about. It was before the Center for Tobacco Research, and the goal and the documents and the jury heard that we saw was so indecision, led people think, well, it might be harmful, it might not be harmful. And that was an organized goal of getting literature into schools, literature to Congress, and have organized speakers. 1978, the National Ambient Air Quality Standards were found for lead, and they were supposed to go down over time. And every 5 years, those were supposed to be reviewed. In 1978, they thought 30 parts per billion was okay to be exposed, so they were set for that. Even though the CDC continually lowered the amount of lead that people could be exposed to, this company paid lobbyists to go to OMB and stop what should have occurred every 5 years. And from 1978, for 30 years, they stopped the level of what lead was allowed in the air from changing. CDC advisory panel under George Bush, they had the advisory panel stuffed with lead advocates so that the level of blood in children would not go down. One of those advocates testified for the company in our case. 1987, the third highest fine in the history of OSHA was leveled against this facility because the workers were too heavily exposed. What did they do? They opened up the roof, got high-pressure fans to blow the lead out into the community so the workers weren't getting high exposure. We asked the jury for $208 million. The jury came back and awarded $358 million. They understood that this conduct needed to be deterred. The costs and the appropriation of external money, the money that they could have spent, they didn't want to spend because it was cheaper to defray regulation. It was cheaper to put their competitors out of business. By 1993, they were the only smelter left. They put them out of business because they could undercut them. And the jury understood that.
Without tort law, there'd be 500 homeowners, households, families in a primarily low-income Mexican and Afro-American community west of Denver who'd still be living in a toxic wasteland. Without tort law, the federal and state of Colorado would have been successful in whitewashing this issue and walking away from this community and telling them that the elevated levels of cadmium, arsenic, and lead that were in the soils and in their houses and in the dust in their attics was safe for them. When ASARCO decided they wanted to settle the case, the community got together and instead of taking a check for money, they agreed basically that we would use that money that ASARCO was going to pay to clean up the neighborhood, not just to take a check or to move out of the neighborhood, but to stay in their homes. It was a huge deal because it took almost 3 years, if I remember correctly. And so for us, it was a fabulous result in terms of working with a great group of people who were otherwise powerless, and but for the tort system, they would still be living in a toxic wasteland.
One of the things I frequently hear is the idea that the entire tort system is all about greedy lawyers. And I was at my 30th law school reunion, and this really pleasant idiot who represents hedge funds said to me, "What do you do?" And I said, "I'm a trial lawyer." And he says, "Oh, so you've made your life all about money." And I was trying to take in the irony of this. And the 4 cases that you just heard described, they're all cases in which corporations were introducing poisons into the lives of actual Americans. They were threatening human lives. All 4 of these cases made people safer. They led to cleanups. They deter corporations from polluting when they have to bear the costs of the harm that they're generating and putting out there. I mean, these cases are not just about money. They're about a lot more than that. But even looking at the issue of money, as I was listening to the cases, by my count, 3 of these cases lasted 16 years. And Mary's is still going. And also, Junior, do you have any idea whether the corporate lawyers across from you were paid during these cases?
You know, it's interesting how much they do get paid. They get paid $500, $1,000 an hour. They spend more on their defense costs than it would have cost in our case just to clean up the mess.
We're alone in court. Maybe there's 2 or 3 of us, and every time we're there, that have 20, 25. Now, every one of them is billing by the hour. Think of having 20 people in the courtroom sitting there.
Well, that's right. They're paid by the hour, and lawyers like at this table are contingency, and they don't get paid unless and until they get something for their clients. And so in our case, we've had the expense of the litigation over 16 years and still not been paid, nor has the money come forth to protect the children.
In our case, the claims are still pending. DuPont is trying to pay the lawyers enough to outlast the lives of the claimants. And when you have 3,500 people that are injured, the court system can't, unless they combine the cases, which may create new law and they may have to do, these people will not live long enough to even be paid. And of course, the attorneys won't get paid either.
Over time, medical malpractice litigation has made medicine a lot safer. And when you or a loved one goes into the hospital, it's safer because of the tort system. Several decades ago, anesthesia was extremely dangerous. I remember a surgeon telling me the anesthesiologists kill a lot more people with the anesthesia than we do with scalpels. In the 1970s, there was a lot of litigation. Medical malpractice rates for anesthesiologists and for hospitals skyrocketed. And the American Society of Anesthesiologists decided they've got to do something about that. And they conducted closed case studies, again, closed cases of lawsuits, to see if they could figure out something about anesthesia risk. You know, you would like to think they did it because they wanted to save lives, but the head of the study, the head of the American Society of Anesthesia study said that they did it because of malpractice claims and publicity arising from malpractice claims. So they discovered a lot of things that they could do to reduce risk. They discovered, for example, that frequently you have one anesthesiologist who is covering 2 or 3 operations simultaneously, or covering one operation after another in quick succession in different rooms, and that the anesthesia machines that dispense the anesthesia were not uniform, and that the machine in one room, you spin a dial clockwise and it increases the flow of anesthesia, and in the next room it's counterclockwise to increase the the anesthesia, and spinning it clockwise will increase oxygen. And that simply by having uniform machines, risks could be significantly reduced. They discovered that being an anesthesiologist is like being a firefighter. It is hours and hours of boredom punctuated by moments of great crisis and stress. And they discovered that they ought to be monitoring automatically oxygen in the blood and carbon dioxide in respiration, and that alarms ought to go off if these indicators fall outside of normal limits to kind of summon the firefighter faster. How helpful was that study? This is how helpful it was. Within 10 years, deaths from anesthesia, and I'm just talking about deaths because there are also a lot of serious permanent injuries, but deaths from anesthesia fell from somewhere between 1 in 10,000 and 1 in 20,000 to 1 in 200,000. That means that today the chances of getting killed by anesthesia is 5% to 10% of what it was several decades ago before this study started. Hey, did it pay off for the hospitals? Yeah. In 1 year alone, the premiums charged for insurance premiums, medical malpractice insurance premiums charged for anesthesiologists at the Harvard hospitals, Mass General, Beth Israel, and the other Harvard hospitals, in 1 year alone fell 33%.
I have come to the view that in many situations, defendants welcome the idea of introspection and the idea of making their practice and their conduct safer. We have seen significant strides in this area, for example, in the healthcare field, where hospitals more recently have become much more open about improving their practices, about sitting down with their physicians and their other healthcare providers when a mistake has been made and having it be a true teaching moment. They've made progress with respect to talking to their patients about why there's been a bad outcome. Sometimes that has been required by statute. We have such a law in Pennsylvania where there must be a disclosure to a patient of an outcome that was unexpected and the reasons for that unexpected outcome. And so in the hospital setting, there was much greater receptivity than in years past. You should look at every single case as an opportunity to achieve structural reform. I had a young man who was a Master of Law student from India in my class a couple of years ago. And he went back to India and served as the law clerk to the Chief Justice of the Supreme Court of India. And they had a medical malpractice case in front of them. And with the judge's permission, he undertook to explain to the chief what the American system of justice was in medical malpractice cases and how India had essentially no viable system of compensating victims of medical malpractice. And he convinced the Chief Justice to adopt a system in India for compensation of victims of medical negligence that, while it doesn't quite get to our standards of fair compensation, it is leaps and bounds beyond what had been the case in India. So not only can we help ourselves and our own society, but this is exportable. We don't have to just export munitions, but we can export justice. And these opportunities are there, but we lawyers who have learned these things, we need to move forward with that in a constructive way with the next generation of lawyers.
Tort law walks with us. It follows our families. It sits quietly in the school dining room. It hovers over the workplace. It joins you as you click your seatbelt in your car, as your brakes function and don't fail. It joins you in the event you come close to an accident. Tort law is the unmasked presence in the operating room. Tort law is the force that requires that pins are supposed to dissolve, and screws that are supposed to stay in place, stay in place. When you work in a field that affects everything you eat and wear and drive, every plane you enter, train you ride, you're in a field of consequence. When you consider the multiple domains of life and the effect, subtle and efficient, of this field, it's hard to come away thinking anything other than this is the best that ancient modality in Sumeria began.
Recognizing new torts, the case study of insurance bad faith. Before this new tort was developed in the law, for almost 200 years in this country, when you had an insurance policy and you had a claim, and they didn't treat you fairly on your claim, maybe they denied your claim or shortchanged you on your claim, you couldn't do much but sue for breach of contract, because an insurance policy is a contract. And under the law of breach of contract, you can usually get the benefits you were due in the first place, but minus your attorney's fees, minus your expenses. So there really wasn't any, what I would call, effective remedy for 200 years in this country if some insurance company treated you unfairly or in bad faith on your claim. This case came along. It was in 1974. Egan was an Irish immigrant living in Pomona versus Mutual of Omaha, and everybody's heard of Mutual of Omaha. By the time it got to the California Supreme Court, because the case was appealed, of course, every big verdict seems to be appealed, it was 1979. 5 years later. And this is where this new tort got developed, with this opinion by the California Supreme Court. And I'm going to give you a few quotes from that Supreme Court decision. The law imposes in every contract a covenant of good faith and fair dealing. So our Supreme Court has said, hey, this may be a contract, but in every contract of insurance, the law is going to impose a duty of good faith and fair dealing. They next said, when an insurer unreasonably and in bad faith withholds payment of a claim by its insureds, it is subject to liability in tort. Now, this is really important because remember what I said? For 200 years, you just had a contract remedy. Now, all of a sudden, this court is saying, well, it's a contract, but if you don't abide by the contract and you handle a claim in bad faith, we're going to transform that to a tort. And that is significant because when it's a tort, you get different remedies. You get more remedies. You get remedies for consequential damages. You get remedies for punitive damages, which you don't get under a contract. It next said, it is essential that an insurer fully inquire into possible bases that might support an insured's claim. So in other words, the Supreme Court said, and by the way, Mr. Insurance Company, if you don't investigate a claim by looking for ways to support the claim, that is also bad faith. And so over the time since this case, they have streamlined and tried to avoid punitive damages by cleaning up their insurance claims practices. They haven't entirely done it. They still do engage in bad faith, and when they do, there is this law out there that helps.
The climate is changing before our eyes. Nearly everywhere we look, we see it happening. In 2007, the Intergovernmental Panel on Climate Change said that climate change was already killing 150,000 people per year. Nonprofit organizations have put the figure higher at more like 400,000 per year and said that by 2030 it could be killing 700,000 people per year. Exxon scientists researched global warming in detail in the late 1970s and early 1980s. The scientists found that the level of CO2, carbon dioxide, the main greenhouse gas, was increasing in the atmosphere. And they said that the overwhelming, their word, overwhelming opinion of scientists was that the source of this problem was the burning of fossil fuels, their main product. They declared, the in-house scientists, in 1982 that, quote, a clear scientific consensus has emerged that a doubling of the carbon dioxide from pre-industrial levels would result in an average global temperature increase of about 3 degrees Celsius, which would be an unprecedented and rapid increase in a mere 100 years. They said that there was, quote, unanimous agreement in the scientific community that a temperature of increase of this magnitude would bring about significant changes in the Earth's climate. They concluded that global warming would cause more rainfall and evaporation, and that, quote, these disturbances in the existing global water distribution balance would have a, quote, dramatic impact on soil moisture and, in turn, on agriculture. And they said there are some potentially catastrophic events that must be considered, such as sea level rise on the order of 5 meters, which, Exxon scientists said, would inundate coastal areas. This was all in the time period 1977 to 1982. And the Exxon scientists gave these conclusions and projections to management, and they issued stark warnings like this one from a 1977 presentation to management. The use of fossil fuels, quote, should not be encouraged, unquote. And man can afford a 5 to 10 year time window to establish what must be done. In 1982, Exxon scientists informed management that mitigation of the greenhouse effect would require major reductions in fossil fuel combustion. Exxon marked the document proprietary and put a memo on it saying it was not to be distributed outside the company. Global warming harms are classic harms to rights common to the general public, harms to natural resources, harms to a healthy and clean natural environment are classic public nuisance type harms. Chevron, ExxonMobil, BP, Shell, and ConocoPhillips, those 5 companies are responsible for about 12 or 13% of all carbon dioxide and methane emissions from the combustion of fossil fuels since 1854. Under the law, when multiple polluters contribute to an indivisible harm, for example, hundreds or even thousands of entities, companies that are polluting a river, they're held liable even though their pollution standing alone wouldn't have caused the harm. This is an ancient doctrine, actually, in the law. It goes back to at least the 1880s in the United States. So we know who the major culprits are. We know how much they emitted. We know the causation between the emissions of greenhouse gases and the harms. And we know that legally it doesn't matter that there are many other contributors to the harm. I've had the privilege of being involved in 2 seminal cases on global warming. One was Connecticut versus American Electric Power. The other was Kivalina versus ExxonMobil. In both of these cases, we sought to use the federal common law of public nuisance. And the long and the short of those cases was that the courts, including the U.S. Supreme Court, said that federal common law is not available in these situations. And so the Clean Air Act, which is what ended up displacing our federal common law claim in those cases, has savings clauses that expressly save state law. And so now it's wide open for the next case to use state law. Global warming is causing severe harms. It's causing them now. We know that Exxon and the American Petroleum Institute were warned by scientists many years ago about the nature of the problem. We know that Exxon and other fossil fuel companies engaged in a campaign of deception and denial that resembles that of the tobacco companies. And we know that injured people are going to emerge in this country and around the world as global warming unfortunately accelerates and demand compensation. The U.S. court system is where they should turn and where they can turn to obtain that compensation, because global warming is a tort.
The potential for cyber torts is staggering. It's all occurred since 1995 when the World Wide Web became commercialized. New platforms are creating new cyber vulnerabilities. We now do banking online. We don't think about it. We have so many. Facebook, for example. Facebook has 1 billion members. We talk about Google. Google, every minute of every day, there's more than 2 million per minute searches. And there's a lot of single people out there. Tinder, for example, there's 700,000 swipes per minute. Staggering amount of potential tort liability. YouTube, every minute, 2.78 million videos being seen. You know, I coined the term legal lag, and I think that's what we have with cyber torts today. They haven't evolved. They're stillborn. They're what one of President George W. Bush's closest advisors suggested, that we keep tort law small so we can drown it in the bathtub. This is what's happened to cyber torts. There's two forces. We know that cyber torts, that businesses have robust cyber tort remedies. We know that just a few months ago, large companies lobbied Congress and were able to convince Congress to enact the Defend Trade Secrets Act, which gives a private cause of action to those businesses who suffer misappropriation of their trade secrets. We know that from studying cyber torts, that business torts, we know that trade libel cases, fraud cases, interference with contracts, they are strong causes of action. The problem is that negligence and strict liability has yet to evolve. Sure, consumers have robust remedies against other consumers. My talk will focus on the two reasons why consumers do not have remedies for negligence and strict liability. The first is the one-sided contracts, the terms of use. And the second is a federal shield. You heard about charitable immunity from Mitchell Garbadian. In Massachusetts, we have a $20,000 cap. Well, all of cyberspace, all businesses who have a website have an absolute immunity from liability for user-generated content on their websites. This means that a revenge porn website where we have an ongoing tort, you can call it invasion of privacy, intention, infliction of emotional distress, defamation, there's no duty to take down under current U.S. law. Recently, there have been a few courts that have found ways to try to find some wiggle room around the Section 230. But the most recent case on the revenge porn was a case called GoDaddy, and they found no duty. So we need another Ralph Nader who can help us challenge Section 230 of the CDA and challenge these harsh contracts in order for cyber torts to grow and flourish and fulfill its historic mission of protecting us all. Thank you.
5 years ago, my niece, Katie, wanted to take her daughter, Audrey, to a birthday party. Audrey was then 3 years old. The birthday party was being held at a children's recreation facility. In order for Audrey to attend, Katie was required to sign a fine print form. Among other things, the fine print said, quote, "The undersigned agrees to defend, indemnify, and hold harmless this facility, its officers, managers, members, employees, servants, agents, and coaches, instructors, and their successors and assigns from and against all legal liability claims, suits, damages, losses, and expenses, including attorney's fees, threatened or incurred, and arising from the child's participation or from any cause whatsoever," unquote. The purpose of such fine print is to prevent people from making use of tort law when they are injured by bad behavior of other people or of businesses. Tort law would normally make a business liable when it's negligence or gross negligence, or heaven forbid, intentional bad conduct, some of which we've heard about today. when that negligence causes someone to be injured. Katie was concerned that 3-year-old Audrey could have been injured by a trampoline that was not properly maintained or by a caretaker who neglected to supervise Audrey properly, especially because it seemed that the words, "or from any cause whatsoever," would include gross negligence by the facility's employees. Businesses that use fine print like this are using a so-called contract, and I'm using the word contract in quotes. They're using a so-called contract to cancel customers' legal rights. I propose that tort law that prevents deception by means of fine print can help us stem this loss of basic rights of redress, protecting us against negligence and worse. There should be a tort to cover deceptive deprivation of core legal rights. Boilerplate is what lawyers call the fine print we receive every day in person and online, which we cannot change and cannot avoid without giving up the birthday party, or the software, or almost anything else we buy online, and much that we buy in physical space too. We shouldn't have to give up services we need because we have lost our rights to legal redress and fear injury that can be neither deterred nor remedied. Protecting us against others that harm us is what tort law is for. These rights deletions are burgeoning in the internet era. We are awash in fine print. The use of boilerplate rights decisions by a few powerful businesses may be forcing other businesses to use them, even if they would have preferred to be more ethical with their customers, because it may be difficult to hold out against the diminished expenditures of the companies using them. The ethical businesses are the losers, and so are massive numbers of consumers. Now, businesses that impose these may be winners in the short run, but in the long run, they may be losers too. It may harm a company's reputation if we can teach everybody how insidious these things are, but worse, at least from a professor point of view and from the point of view of civil society in general, I want to tell you that such companies are weakening the infrastructure of civil society, and infrastructure they need for their own protection too. Right now, it seems that tort law may be the best way to cope with mass market deception, but by fine print.
The so-called tort reform movement that over the last few decades, culminating and peaking from the mid-1990s through mid-2000s, now has led almost 2/3 of the states in this country to enact various types of laws that make it very difficult for injured people to get fair access to the civil justice system or dramatically curtail the amount of recovery they can get for devastating injuries. The most common type of legislative so-called reform has been to put caps or limits on the amount of non-economic damages that people can recover in certain types of cases, predominantly in medical malpractice cases, although some states have put on caps for any type of tort claim. And usually under these cap laws, the recovery is limited for these so-called non-economic damages to either $250,000 or $350,000. Usually the caps never get raised and they're not indexed to inflation. Now, what are non-economic damages, you might ask? Well, they're basically all the damages that you can recover for everything but your medical bills and your lost wages. They compensate people for things like trauma, pain, depression, overall harm to mental health and well-being, impaired quality of life, damage to your sexual functioning, ability to engage in or enjoy intimate relationships or communing with loved ones, harm to your reproductive capacity. Indeed, many people would consider these aspects of life the most priceless, and yet the impact of these caps on damages for them has been to render the priceless virtually worthless. And I think when we look at the pervasive, unfair, and unjust impacts of these caps, we can truly say that they undoubtedly earn the epithet tort deform. So let me give some examples of how these cap laws are in fact tort deform and how they harm particular types of people, notably women, sexual assault victims, children, and the elderly, but in fact harm all of us as members of society. In cap states, studies of how lawyers have actually dealt with the cap say that on the defense side, lawyers have seen their business dry up and they've turned to other areas of law. But on the plaintiff side, lawyer after lawyer in a cap state says basically they can now only afford to take a medical malpractice case for wealthy people for whom the injury caused by the malpractice will lead to long-term periods out of work, therefore with high economic loss damages, the type that is not capped. Because these are very expensive cases to bring. The expert costs alone could overwhelm the amount of the cap. So they have to leave on the table very meritorious claims with admitted negligence, obvious causation, very serious medical error, and serious injury just because the plaintiff isn't wealthy, and most of their damages will be in the non-economic category. This certainly distorts or deforms the civil justice system. States with the capped recovery in medical malpractice cases, the amount of unsafe care and adverse incidents actually increased from before the cap and in comparison to states without caps. There was more medical malpractice and more bad outcomes for patients. By the way, in capped states, the juries don't get told there's a cap. So they award what they think is fair for the injured person, and then the judge has to come along and impose the cap legislation. So what I found is that in pediatric malpractice cases, when the baby or the child survives, they have years of extensive medical bills, so the economic uncapped damages are very high. But in cases where the baby or child dies as a result of the malpractice, the medical bills get cut off. And the juries tend to award 97% of the total compensation in such cases in the non-economic loss category, the capped category. So the impact of the cap is to reduce the overall compensation in these cases to virtually the amount of the cap. And predictably, what happened in California is what I reported about in Texas. Lawyers unable to simply afford to bring these very complex, very expensive medical malpractice cases. Indeed, I uncovered incidents of parents who had pursued a claim with a lawyer while the child was still lingering still alive from the malpractice, and the minute the child died, the lawyer said, "I'm very sorry, the case just is no longer viable to pursue." So the medical error goes undeterred and unredressed. In fact, the overall conclusion of my research was that I call women, children, and the elderly the hidden victims of tort reform, the primary evidence of tort deform.
So you've heard, I'm sure, quite a bit today about what kind of battlefield the civil justice system has turned into in this country. I think probably everybody here and everybody watching has had their own rights weakened in some significant way. Probably you're unaware of it as a result of the tort reform movement and the side issues that go along with this, like forced arbitration. And in addition, if you're a trial lawyer, you know how polluted the juries have become because they've heard a lot of very negative information coming out of some of the PR firms, and some maybe not even aware of where this information is coming from. But a lot of juries are convinced that there are too many frivolous lawsuits, that people go to court to try to win a jackpot, et cetera. And so even though there is clear negligence, even though people have been seriously hurt, sometimes juries are still not willing to trust that they are legitimate and their case is legitimate, and will exonerate the corporate defendants in those cases. So it's been a difficult journey for a lot of trial lawyers, I think, in the last 20, 30 years, as these PR campaigns have sort of infected people's minds. And money is clearly responsible for a lot of this. The American Tort Reform Association was formed in 1986 with about 300 major corporations and insurance companies in particular, dumping a lot of money into this issue as a lobbying and public relations force. in 1998, the very same year I formed my organization, the U.S. Chamber of Commerce formed the Institute for Legal Reform, which is their tort reform branch. It alone is one of the largest lobbying forces in America today, even separate from the even larger U.S. Chamber of Commerce itself. Statistics are basically all on our side. The number of lawsuits in this country has been going down for years. The number of tort lawsuits are a tiny, tiny percentage of civil justice cases, of civil cases that are brought in this country. Only 10% of people who are injured even file a claim for compensation. Only 2% file a lawsuit. When it comes to medical injuries, which are now the third leading cause of death in America, only 1 to 2% of people that suffer through medical malpractice file lawsuits. So, I mean, it's a ridiculous also disconnect in the way people view Americans as being sue happy and running to court all the time versus what's really happening in the justice system. But unfortunately, when you argue these statistics, people don't believe them because it contradicts their worldview of things.
Immunity is what the corporations really want. It's really strange. The corporate structure was set up to limit the liability of shareholders. And ever since the early 20th century, corporate lobbyists have been trying to limit the liability of corporations. A legal fiction, not a human being. The second issue is impunity. This is where if they can't destroy the law of accountability because they carve out an exception for themselves and become immune, they have so much firepower that they intimidate law enforcement officials who, if they're not politically harassed by Congress or by the White House or by the governor, they don't have the budget to handle a gigantic law firm that can drain a third of their staff on one case. So that's how they achieve impunity. And that's Wells Fargo. When the government said, well, you know, what do we want to get dragged down for years and use up our legal hours with this giant bank that made in the last quarter $5 billion in profits after taxes? Well, we'll fine it $185 million. $185 million for a premeditated crime that they knew about at the highest levels, and no one's demanding their resignation. No one's demanding accountability. So these are the two. We're destroying, in all kinds of ways, the rule of law. Subordinate to the rule of raw corporate power and turning the government into a corporate state.
Tort reform. I mean, that's what they call it. What do we call it? We call it the destruction, annihilation, and erosion of people's historic right to go to court. So we don't want to engage the debate in abstractions about lawyers and lawsuits. We want to talk about what's really going on, which is what people really care about: their health, their safety, their pocketbooks, their families. And so some of my favorite words are greed, ripoff, betrayal, medical mayhem, crime in the suites, consumer rights, rather than tort reform. But once voters learn who's really behind these restrictions on the right to sue, they get angry, they get inspired, and they take action. And so what we have realized in California is that rather than fight a defensive battle against tort restrictions, we go on the offense. We seek proactive consumer protections in insurance reform, in consumer rights, in the corporate death penalty, and corporate 3 strikes and you're out of the state legislation. So the agenda gets flipped around. And when we passed in 1988, Carl didn't mention this, the voters passed a proposition that was directed at the insurance industry, because the insurance industry had been saying that we need changes in the tort laws in order to lower insurance rates. Well, and the voters fell for that twice. But in 1988, the voters realized that that was a fraud, and they passed an initiative to regulate the rates and practices of insurance companies and forced auto insurers to give back $1.2 billion in refunds and blocked another $100 billion in auto insurance rate increases since then. And since then, We haven't heard a peep from the insurance industry in California about so-called tort reform. It's a lesson that the insurance companies very quickly learned and have not forgotten in the last 28 years. You have to put a human face on the issue. People relate to stories, not abstract legal debates. We want to focus on the heartrending tragedies and the human victims of corporate crime. And it's particularly important in what Ralph Nader has called silent violence, that is medical malpractice, the poisoning of food, water, and air, things that, unlike air crashes or car crashes, are relatively invisible or happen behind closed doors.
There has to be transparency. How do you fight this? For instance, the Boston Globe stepped in and they said, we want to look at these records that have been kept under seal, because the judge had determined all records concerning discovery in the Gagin cases, and there were 86 at the time, would be kept under seal until time of trial, so that we could use the appropriate documents at time of trial. So they went in with their First Amendment powers, and the judge said, you know, Boston Globe, you're right. Here are the records. And it showed the wholesale rape and sexual molestation of children for decades by priests, while supervisors knew of those incidents. It's continuing today. Statute of limitation laws have to be enlarged. The statute of limitation laws in most states are woefully inadequate to protect innocent children. I often hear people say, well, you know, they happened 30 years ago. How's a person supposed to defend themselves? Well, in murder cases, there are no statute of limitations. And they try cases, murder cases, that are more than 30 years old, and due process works fine. And this is sole murder when it comes to child abuse. Confidentiality agreements have to end. That was the point of the 86 Gagin cases. They offered me millions of dollars on behalf of my clients. They wanted my clients to sign confidentiality agreements. They asked me that during the mediation. I told them I had to go to the men's room. I'll be right back. I got in my car and I drove back to my office. Mediator said, where are you? I said, tell them I went to the men's room in my office. See you later. Confidentiality agreements. Secrecy. You've got the priest telling the child to keep it a secret. The supervisor telling the mother to keep it a secret. Canon law, keeping it a secret. Confidentiality agreements, keeping it a secret. We have to use the law as a tool to end secrecy by corporations.
The American Museum of Tort Law, which, as you can tell, I've mentioned 14 times, check us out, website, come and visit, was created to really fill a need that I think has been vacant for too long, which is accurate, authentic, dispassionate reporting about tort law, how it works, how it benefits us, aimed squarely at the public. There are other organizations that deal with the legislative attacks on tort law. But until the museum was created, there has been no institution aimed at educating people. And from our limited experience in 1 year of operation, it really works. Thousands of people have been through the museum and come up with a real appreciation for the law and how it works and how it benefits them.
So even if these lawsuits fail, they serve this very positive purpose in the fact that they allow people who might not otherwise have inputs into important policy debates in this country to raise arguments and judgments and issues in the course of political and other types of deliberations of great importance. This in itself has an impact on the regulatory process that is maybe going to make the ultimate decisions on these issues.
We have to keep developing new torts, like insurance, bad faith. The law schools have tort programs. They teach the traditional torts, assault and battery. I would encourage them, and also encourage the textbook writers, to at least include in their tort class the new tort of insurance bad faith. I would like to see, let's say, the tort of insurance bad faith in all the states and in the textbooks, in the law schools.
We have been working with more conservative organizations who strongly believe in the Seventh Amendment, who believe in the Constitution. Remember, the Seventh Amendment is about the right to civil jury trial. They believe in separation of powers. They don't believe that the legislature should be telling local judges and juries what to do. There's a strong sense that local government is the right way to go, and you don't have really anything more local than a local judge and jury making a decision on a case-by-case basis. So I think another positive thing is that we've been able to find new allies in this fight.
The corporatists want to play a very vicious game. They want to sidestep contending in court, and they want to win by campaign cash greasing of lawmakers in state legislatures all over the country, who then pass laws that, from an absentee position, tie the hands of judges and juries all over the state, who are the only ones who hear, see, and evaluate the evidence in each individual case. That gives new meaning to playing dirty. They're not willing to contend on the merits, they contend on cash bribes. Breaking through power means resuscitating and expanding the law of torts. What we need to do is start thinking in new and bolder ways. Here's one proposal. All attorneys licensed to practice law are officers of the court. When a corporate attorney or attorneys, as officers of the court, put in forced arbitration clauses in fine print contracts on behalf of a certain corporate client on a matter that is before them, they are closing the courtroom door for all the people who deal with American Express, all the people who deal with the Hospital Corporation of America, all the people who deal with some giant housing apartment complex. When they close the door arbitrarily across the board, I believe that is an obstruction of justice. I believe that is a violation of the canons of ethics. That should be pursued by the bar regulatory organizations in the 50 states. We have about 50,000 practicing trial lawyers in the country. What if they decided that they were going to speak to a total of 1,000 people a year? School assemblies, clubs, different gatherings. It's not that hard to reach 1,000 people when you're living in a community. That means that they could reach 50 million people a year from all ages and backgrounds with their message, which I think is a very powerful message and well documented, as Joanne Dorschel and others have pointed out. They should try to get this as part of the curriculum in the schools. They should try to talk about children and parents not only defending themselves from predators, but learning about the law that can defend themselves from corporate predators, commercial predators, not just street predators. I think another thing that we should do is ask some of the wealthier lawyers to tithe themselves 1% a year of their fees and establish civic groups in every state defending the legal system. These civic advocacy groups can also enlist the help of plaintiffs who have gotten justice. In most states, there is a tortfeasors lobby group. It's called Citizens Against Lawsuit Abuse. Instead, we should establish groups to counter them, Citizens for Lawsuit Use. There's one in Texas called Texans for Public Justice that's done a lot of good work and actually got a lot of good media and is supported by the trial lawyers. What about all the other states? There are a lot of other things that lawyers should do. Gag orders. I've never met a trial lawyer that likes confidentiality agreements as a condition of settlement. but they have a priority for their place. So they close down their obligation to inform the public of the facts in the case. They're put in a conflict of interest. That should be an unethical practice by a defense corporate lawyer who demands it as a condition of the settlement. That should be an unethical practice, violation of the canons of ethics. We also need lawyers to do what Bill Chernoff has done. His alma mater is Wisconsin Law School. He has set up a consumer law clinic at the law school. So young law students can learn about it and make careers out of it. We need more of that. We need wealthier trial lawyers set up their own foundations so they can supply grants to law students to do rigorous research in many areas for which there is no research. All of these can be done with a sense of urgency. All of these can be done with an awareness that it's not enough simply to nurture a few trees in the forest and ignore the dwindling forest and not look at the big picture. And recovering tort law is looking at the big picture. And just let me leave you with the final statement once again. If we are to have a democracy, as Judge Learned Hand said so famously, we must not ration justice. Thank you very much. Thank you for being here. Thank you for staying. Just spread the word. Thank you.